ethics for massage and bodywork therapists. And we're also going to be covering roles and boundaries. So know that that will adhere to those requirements also. Just also for the webinar audience, I'm going to introduce myself, tell you a little bit about me. Those of you that are here do know, so I appreciate it. I'm Prepo Teplitsky, and I've been a body worker since 1996. I originally learned at Esalen Institute, and I'm certified Esalen practitioner. And we'll talk about Esalen massage because it has some interesting ethical issues around that also. And I'm also a licensed counselor. I have a master's degree in counseling and psychology. So at times I will also be bringing in some ethics around counseling and psychotherapy, which is similar and different to massage and bodywork therapists. I also teach several CE classes. I've been teaching ethics for about 12 years. I've been teaching a couple classes called Integrating the Emotional Body, Sexuality Issues in Massage, the Unspoken Energy. And that class came out of a lot of the ethics classes that we just don't get enough exploration around sexuality issues, and we'll be touching upon it today. So, and also a somatic psychology course, which most of you know me from, that I love to teach. So, why don't we talk a little bit about what we're going to be addressing, the issues. First, ethics is a agreed upon moral behavior, basically. It's not a law. It's more or less what our profession has agreed that is morally beneficial for our profession, for the safety of the public, and for the safety and intent and benefit of our clients. So I wanted to make that distinction because it's important to know that some ethics are strictly for the board's jurisdiction, but some ethics may also go over to some civil aspects of jurisdiction, which we'll also talk about. And what's interesting that I find is that learning about our professional ethics, at times our personal ethics are going to come in because we have our own moral code of behavior. And when our professional ethics come in as a moral code of behavior, they may conflict. So we'll be bringing that up, and you're welcome to ask questions anytime. So some of the topics that we're going to cover are going to be confidentiality, dual relationships. We'll be covering scope of practice. We'll be covering a psychobabble term, transference and counter-transference. We'll be covering gifts and barter and trade, and especially boundaries, personal and professional boundaries, informed consent, consent to touch. And at times they're going to weave in, we'll be interweaving that in throughout the class. So anytime that I do bring up a subject, if you do have questions and you do want to bring it up even though we finished it, go ahead and bring it up. It all relates. Okay. One of my favorite topics is confidentiality, and it wasn't until I was a client. What I mean by that is I think that as practitioners, the more that we're on the other side of the table, the more understanding that we're going to have around all of these issues. So about 10 years ago or so, I was sharing an office with an office mate, and we decided to do a trade. First time we did a trade. And I was the receiving end of it, and I was lying on the table and received a massage for about 10 minutes. And about 10 minutes to the massage, my office mate said to me, "Wow, Prepo, you're really tight." And I thought to myself, yeah, that's why I'm on the table. I need a massage. I'm really tight. And then another 10 minutes went by, and she said it again. "Wow, you're really tight." And my psychic mechanism at that time went, "Oh, Prepo, bad Prepo. You haven't gotten a massage in 3 months, and you tell people to get it so often." And so I felt some shame. I felt etherically my energy started contracting. My boundaries weren't as clear as they are now, so I didn't really say anything to her, but I can feel that I physically and energetically kind of shrank. And about a week after that, I was walking with a mutual friend of ours, and she said, "Oh, I heard you got a massage by so-and-so, and you were really tight." My drama queen came up. I was just like, "I can't share an office with you anymore." I walked in, and I calmed down. 6 months later, it took me a little bit, and we had a great discussion. She really understood. She was very apologetic of the boundary crossing in some ways, of course, around confidentiality. But that brought up my rabbit's ears around the importance of keeping confidentiality. Even though that might have not affected some people, it affected me in that way, that I felt in some way ashamed of the tightness of my body, the pressure and the stress that I was in, that it was discussed with somebody else. So that's one of my favorite topics. And what's interesting about confidentiality, well, let's just say, do we as a group here have agreed upon confidentiality? Some things that we might say, we feel might, even though the audience, the internet and web audience won't know exactly who you are, but do we feel confidence to have confidentiality among ourselves today? Anybody have an issue? No? Okay, good. So with that, I find that interesting, because what we're going to be covering today is we're going to be covering the professional ethics for bodywork therapists, but also what's important for us to know is state regulations and state ethics, the State Practice Act always supersedes the national. So for us, it's going to be North Carolina, and we'll be bringing some of that up. And for other people, it's going to be the state in which they practice in, which may be different from state to state. So I've given you a handout with information from the North Carolina state regulations. They're going to be very similar to other states, but they may differ. So those of you that are going to be practicing in another state, those of you that are practicing in another state, really need to look at what are the state regulations. So they might differ from what we talk about today. So since we have agreed upon confidentiality, I'd like us to read, or I'll reference one of the pages, and that would be on page 14. And I'm going to read it for the audience so they don't have to have this handout. It says, informing board of violations. It's right in the middle of page 14, 0.0514. And it says, licensees with actual knowledge shall inform the board within 15 days of any person practicing without a license or any violations of the Practice Act when there is a potential for malpractice as defined in Rule .0102. It goes on to saying continuing duty to report crimes and civil suits. Licensees, that's us, with actual knowledge shall report to the board any and all charges of the following criminal offenses, whether committed by themselves or other licensees, which include felonies, crimes that involve moral turpitude. I don't know how clear that is to you, moral turpitude. It's not so clear to me, but we'll figure it out. Alcohol and drug-related offenses, sexual-related offenses, and assaults. So basically what this is saying is our board, our state, requires us to report any violations of massage therapists that violates the Practice Act. We just said that we have agreed upon confidentiality. How does that work? Interesting dilemma, huh? Any thoughts on what do we do if one of us discloses a breach of confidentiality and it may violate a Practice Act, but we just said we had agreed upon confidentiality? What happens? Everybody's looking. It's way too early to ask that kind of question, right? Any thoughts? You can just throw them out.
Would you approach the person, or, have a conversation at least to start with?
Yeah. One aspect is to directly talk to that licensee. I always think that that's beneficial, to get first-person account of the experience as opposed to hearsay. For instance, I had a person in one of these classes, an ethics class, that was reported to the board for not practicing without a license, and the reason was that they advertised in a newspaper without their state license number, which is a requirement in our state. Somebody, another massage therapist, saw that and called the board and reported them. Well, what happened was the newspaper just forgot to put that person's license number. So if the person reporting would have called directly, you know, I see that you're practicing without a license. In our state, you need a license. I'm uncomfortable with you doing this. The person could have said, no. I have a license. They forgot to put it. I'll fax it to you. And it would have been done. So, yes, talking directly is very important. And is there an aspect of, does confidentiality trump this requirement as a licensee? No. Do you have a thought about that?
They are what they are.
They are what they are. So that's a requirement?
It's a requirement.
Right.
You know.
So it actually has a higher level of status than confidentiality between two people.
Right.
It trumps it.
So what I'm hearing is that the state requirement for us, that there's a required reporting, trumps confidentiality. There are some things that trump confidentiality, exemptions that I'll cover. But what this riddle that I'm kind of giving you, throwing out, is that we cannot have confidentiality. Confidentiality is only between practitioner and client. So even though we stated that we have confidentiality, it will not stand up. It's a fiduciary agreement between practitioner and client. Some of the exceptions may be, though, supervisor and supervisee do have a level of confidentiality. And that depends on state to state. So just to know that. I hope to scare anybody off to disclose today, but just to know that when we're talking about confidentiality, we're always talking between practitioner and client. Okay? So some of the cursory aspects of confidentiality would be keeping our clients' identifying information in confidence. That's written and verbal. So that means any written identifying information, when you take an intake form that has the client's name and phone number and so forth, needs to be kept in a locked and safe environment. A cabinet, a locked office, that's fine. What I find that we're most laxed in is more about the verbal aspect of confidentiality. Because some of us practice in towns the size of where we are in Asheville, and we know many of our clients, and our clients know them also. We get referrals. So we have to be careful around just even acknowledging that somebody is our client. For instance, if Joe refers Jim to you as a client, and Joe knows Jim has come and seen you, and the next time Joe comes in, he says, hey, how's Jim doing? I know he had a bad back. You can't say Jim is doing fine. You can't even acknowledge from a confidentiality standpoint that Jim is your client, even though Joe knows that. So the challenge with that is when it comes to speaking about, even if you talked a little bit about how Jim is doing, even Joe might wonder, I wonder what Prepo says about me if asked about that. So it's a lot neater and tidier, and to keep all of the aspects of confidentiality. What I do in that circumstance is I just put it right back onto the client. I say, oh, how are you doing today? What's going on with you? And most people, moi, me, they love to talk about, right, themselves. So if we just go ahead and deflect it back, and we can very well bring out that confidentiality is very important in my practice and to me ethically, so I don't disclose clients' information. And I think that will also bring some safety to people that ask that too. It can be interesting. It can be some challenge. For instance, let's say you have a husband and wife. They're your clients, different times. Of course, they both know that they come to you as clients, but they are separate clients. And let's just say you had one of those partners in one of the massage that you are performing, they happen to have a behavior that is sexually inappropriate to you. You deem that inappropriate, you decide that you want to stop the session, and you actually decide to terminate that client. Gender sakes, let's just say the wife comes in the next week and she says, what's going on? Why aren't you seeing my husband anymore? Can you tell her the reasons why? I say no. Right. No, you can't. However, your personal ethics might be, girl, you got to get yourself another man. Get out now, right? So, right, professional ethics you can't. What if you have a couples massage? Anybody have done a couples massage before, right? Couples massage is where you have both partners in the same room, two separate massage therapists massaging each of the partners. And let's just say one of those clients does that again. In their behavior, they make it sexual inappropriate advancement to one of the practitioners. The practitioner decides to stop the session. The other partner, wakes up groggily and looks over and says, whoa, 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 what are you doing? Why are you stopping? Can you tell that partner? Anybody say yes?
No, but I feel like that's kind of hard to hide in a couple's room, what's going on.
Yeah.
I mean, just from my personal experience, like the tables are pretty close together and you can
It's hard to
hear
hide.
a lot. I mean, so I would not say anything, but I think that it would be obvious
It's hard to
from another
hide.
table that something.
But ethically, can you?
Oh, no, ethically, no. But
Anybody say yes? Can I hear yes?
I think, well, I'm not gung-ho yes, but I think if you have a disclosure statement in advance,
And the disclosure statement would be?
that as long as you have a couple in there, that they agree to share information.
You're getting close. It's the aspect of if you do a couples massage, you don't need a disclosure. You just need to say that it is a couples massage. If they sign the informed consent that it's a couples massage, the couple's the treatment group. So whatever goes on in the treatment group is fair game, right? So you don't need a specific lines and sentences that say that confidentiality is maintained within the treatment group. All you need to say, it's a couples massage. So the couple is the client, right?
that's pretty rare in a spa, though.
Yeah, it's to do a couples massage,
No,
to
I
state
mean,
that,
yeah, to have it say like, you're
Yeah.
doing a couple's massage, like that doesn't happen where I work.
right,
But they normally pay for it as being a couple's massage.
Right.
Which means that it would infer that they've agreed to a couple
But
massage.
That's true.
Is that true?
Well, as long as it's stated that they're signing, that they're signing for the intent of a couples massage, not just an individual massage intake,
Okay,
right?
so if they pay together for
Yeah.
massage, that's like the same thing.
Yeah, as long as there's some piece of paper that's agreed that it's a couples massage. Because we need to inform our client that this is what it is. Whenever we have an informed consent, we are informing the client of the procedure of the massage. So if we're doing a couples massage, we're informing them that even though there's two separate people and two separate massage therapists in the same room, the intent for the client and the intent for the massage practitioner is a couples massage, and that needs to be stated, right?
What about verbal consent versus written?
That varies. That varies for state to state. It varies for things like informed consent. In the state of North Carolina, we need informed voluntary consent to work on the gluteal muscles and also for breast massage. In other states, it might be written consent. So if you're hesitant, it's much better to go the extra aspect and get a written consent, right? But verbal is fine in the aspect of, for instance, where it says gluteal massage. What I generally do is I go over in the beginning of my massage intake with somebody, and I tell them what the massage will consist of. Many things, right? The draping, what it'll consist of. If they have any issues around the massage, the environment, the pressure for them to talk to me. And I also tell people that a lot of us hold in the gluteal area, and so I'll be working on your glutes. If the person just looks at me and just listens, they've just given me verbal consent. If they went, no, stop, they didn't. So I don't need written consent according to our state to do that. Some massage practitioners have an intake form that lists specific areas of the body that people do not want touched, feet, hands, you can put gluteal and so forth, right? And you can know by that. Is that a question?
When we're talking about confidentiality, I work with a team,
Mm,
and it's
good.
usually, someone will get injured during a practice
Right,
and goes to the coach and discusses with the coach, what should I do next? How
Right.
should I move forward? And he will usually say, I think you should go see this practitioner, and has a tendency to send me a text message and saying, did this person come see you? How did it go? What happened? What do you think their injury is? And generally a lot of the different teammates will talk about sessions together, but it can be,
Yes, right,
because he's also my coach, because I'm a part of the team.
Right.
And so it gets to be kind of a,
it does. I guess I can speak to that more in general, because I'm not sure about the specific of that question about working as a team, because if you're working as a team as massage practitioners along with the clients, it's a little different than if you're working as a team, for instance, a spa, an organization. When a client comes into a spa, they're contracting the organization. They're not contracting you individually. So the client's information then is privy to the organization. And it's up to the organization to keep that confidentiality, but they can give that information among themselves. What I mean by that is client intake forms and identifying information needs still to be kept in a secure environment, not on a administrator's desk where also clients are walking by in a spa to see it. But other practitioners can get that information from each other to work on the same client if in the future they're going to work on it or in tandem. For instance, even in, let's say, a medical practitioner's office that people work in a co-op, if you're working together in a healthcare profession like a chiropractor's office, if the client comes in and you are under that employment, even if you're contracted, you're under that organization, then the people in the organization can exchange information. So I'm not too sure of how that works in your instance. More what would be an extra safe boundary with confidentiality would be what's called get a consent release form. And a consent release form is where a client gives permission to a practitioner to discuss their work with another party, a third party, which can be another health practitioner, which can be a family member, and it can come from the practitioner. The practitioner can request it. I think it's very vital to know that when one of our clients is working with another health practitioner and we believe that their work influences our work or vice versa, for the benefit of the client, it's ethically responsible for us to have that discussion with that health practitioner. So we may ask that client, I know that you've been seeing a chiropractor for the last 6 months. I would like to have a discussion with the chiropractor to see to know what their treatment plan is, to understand their work, so that we can work in conjunction that would be most beneficial to you. A psychotherapist. It would be great to also have that relationship with a psychotherapist to know maybe there's areas that would be beneficial for both of you to know that we're working on, because we all know how emotions are held in the body, and a lot of the stress that is also mentally and emotionally affects the client on many levels. So especially if you have relationships with those health practitioners, and forming that relationship is also very important. So that's one way to have that. So a consent release is just basically a form that says, I, Prepo Toplitsky, I, the client's name, I, client Joe Smith, gives Prepo Toplitsky permission to discuss our work with the following people. And then you write in those practitioners or those people's names and phone numbers. I also have a limitation. I put limitation, none, the word none, or lines for them to fill out. You know, don't discuss my left pinky toe. A client can put that on there. Most of the time, of course, they put none. They're going to hopefully have trust in you and do that. So only one of the practitioner needs the consent. Both do not need to get that signed by the client. However, I think it is beneficial that if you know a health practitioner has that consent release and is talking to you, to just say, would you please send me over the copy of that, so you have that for your records, so that 4 or 5 years down the road, if something comes up and that chiropractor is now owning a surfboard shop in Costa Rica, and it would be good that you have your copy. So, and in getting the consent release, it's also important, like if you do get a call, let's say from a chiropractor, and that chiropractor says, I'd like to discuss the work that you're doing with Jane Smith. And then you need to ask, do you have a consent release from Jane Smith? And if that chiropractor says no, then you can't speak to that chiropractor. And you really can't even acknowledge that Jane Smith is your client. Just say, you need to get a consent. When you have a consent release, please fax it to me. Right? So that would be one of the exceptions to confidentiality, would be to get a consent release. So that might be beneficial in your circumstance, is for those clients, maybe even right in the beginning, to sign a consent release to the team members of that organization. And it would be good to have discussions with those team members around confidentiality, that those verbal discussions are held within the team group and not talked about with other people outside that realm. Because of the sensitivity. Even though we know that we may be talking about specific issues of body work focus, people might think that we're talking about all kinds of other issues, because that comes up in body work. We know that. It comes up in intake when we're talking to a client. A lot of personal information is exchanged, a lot of people's personal circumstances, where they are in their personal life, stress, and their relationships and so forth. What's the protocol of when you see a client in public? Do you know the protocol?
You let them approach you.
Right. You wait for the client to come up to you. You ignore them, no, basically. Right. You wait for the client to come up to you. And what I find that's interesting is we learn that, we know that, but our clients may not. And I had a circumstance some months ago where a psychotherapy client, we're under the same aspect of protocol for confidentiality as we are in the licensed massage profession. And that client, we didn't bump into each other, but there was a distance walking in the pathway of a street. And I looked over, and he didn't make direct contact with me. So I, of course, didn't make contact with him. And some weeks later, I got a scathing email that he was very hurt and angry that I ignored him. And so I sent an email to him, of course, apologizing for his experience and telling him what the protocol of the profession was, and that is basically waiting for the client to approach us. So from that experience, I then put that in my intake, which I think is beneficial, to put that in your intake or to discuss it right off the bat with your client when you first see them and say, you know, we're in a small town, we might bump into each other. How would you like me to approach that? The protocol is this, and your client will tell you. Some will say, of course, oh, I have no problem, please say hi, come up to me. Or, yeah, great, wait till I approach you. So you'll know that. You'll know that. Sometimes you won't have that benefit of a distance. Sometimes you'll bump into somebody, you know, literally do that. And that happened to me some years ago, where at a grocery store, I literally bumped into a client, and he was with his wife, and his wife looked and said, "Whoa, oh, how do you know each other?" And I pride myself in an elephant memory. I have a really good memory, but I totally dissociated that moment. I don't know what he said. He must have said, like, we were jackhammer operators together in Ethiopia, because I was shocked. But I remember saying, yep, that's exactly how we know each other. And the next week when he came in for his session, I said to him, hey, what was up with that? And he said, you know, Prepo, my wife and I have such a tight budget. If she knew that I was coming every week to get a massage, she would just bust me up. So we never know what goes on behind closed doors. So it is beneficial, you know, to do that. And it's hard to you know, again, bump into a client and hold that aspect. You know, even in a party, I went to a party a few weeks ago, and there was 4 or 5 clients at the party. Some of them approached me, and others almost acted like, one other person acted like they didn't know me. And I respected that and adhered to that, because it could be a circumstance where if we're talking, somebody comes up and says, well, how do you know each other? Now that client is put in a position to disclose. They don't have to disclose the truth, but it also might compromise that they don't want to have to not tell the truth. So we just don't want to put that client in that circumstance. Other aspects of confidentiality that are interesting is, it's stated in here on page and the page numbers are in the top left corner. Page 11. As we discussed, it says maintain the confidentiality of all client information unless written disclosure is consented by the client, consent release form, or required by law or by court order. So what I find that's interesting that most of the states will write is or by law. The challenge that I have with that many of you might have, is the last time I read the North Carolina statutes of law was never. So it's not as specific. So we might have to do some due diligence. That might mean that if you have some doubt or not as sure about some aspects of it, call up the board. They'll give you an answer, or they'll refer you maybe to even a statute and law for you to look up. Or required by court order. Court order is a subpoena. It's a court order. It's not a letter or a phone call from an attorney. What that means is, even though we are not held in privileged confidentiality, like maybe like a psychotherapist in my other profession that I'm held, I can hold privilege different than I can in massage therapy. We still are viable to confidence with the client. What I mean by that is, if a attorney sends a letter and it's on the client's behalf, so it's the client's attorney, I'm assuming that that attorney will have a consent release to talk to you. Our clients will want you to talk to that attorney. And again, just ask that attorney, do you have a consent to speak? If they don't, you can't talk. However, let's say it's a letter or a phone call from a attorney that is not representing your client, then you do not have to at all acknowledge or that phone call or that letter. You don't have to do that. And I could be wrong. We have a attorney here. You can give information if that has happened, but is that accurate at all?
Yeah, it's similar to the legal profession, which is you don't discuss anything on behalf of the client unless you have the client's authorization to do so.
Right. So I guess what I'm saying is, don't feel, I got a letter from an attorney, I have to. No, only by court order, right? So. It also says that we shall protect the client's identifying information in all social conversations, advertisements, and any other manner. So protecting identifying information in social conversations could also be as peers and colleagues, we may want to exchange case studies, which is very beneficial to do peer consultation. When we do that, we need to keep our clients' identifying information confidential. What I mean by that is I can say to one of you, I have a client, 55 years old, he had a car accident, he has a sciatica condition, and I can talk about that case. I can't say, I have a client, 55 years old, car accident, sciatica condition, and he has a mole on his left upper eyebrow, and he's the owner of, I can't give that kind of course, identifying information. And we have to also look at what comes up for us about when, let's say, we are massaging someone who may be celebrity or important or knows someone else. Ooh, I'm massaging the boss of my friend's wife. We have to really adhere to that confidentiality to keep that safety. We also have to maintain client files for at least 4 years from the act of termination of the client and therapist relationship, and we need to store and dispose of those in a, of course, secure manner. Right? Protect the interest of clients who are minors. So what that means is that we need to also get a consent to perform treatment by a third party, which would be a guardian or a parent. Okay. So what is interesting that I'm going to put out to you is that here's where I would like to put some comparisons to counseling and psychotherapy and massage. And one reason I do that, of course, is because I hold both licensure, but also there's times where we feel like our client is disclosing a lot of personal information, and we're a little bit on that boundary of what's going overboard as a massage therapist and what is counseling. And to kind of put it directly, what I would say is that for instance, when I am doing a massage, I put on my massage therapist hat, and that is reflective listening, just like we all do. If a client is talking about their personal experience, that they may be stressed and sad and angry, I will acknowledge that. I hear that you're very sad and angry. Is there anywhere that you're holding that in your body? That is where it goes into the information that I need as a massage therapist to be able to handle it on the table. That's the distinction that I make. In psychotherapy and counseling, we process clients' issues. In massage therapy, we handle it on the table. One way that I find that's beneficial when you have a client that just is going on and on and on about their personal issues, a couple things are probably coming up for us. Boundary around time. How do I interject to know that it's time to get on the table? It's been 15, 20 minutes. How do I interject without them feeling cut off, disrespected? One of the best ways that I know is that, thank you so much for telling me that information. I need to know that to be able to give you and serve you in today's session. Let's go handle that on the table. Most of the time, my experience is people go, yes, let's go do that. Okay. So with that, there's some aspects that's different with the two professions of confidentiality. And that's around, for instance, child abuse and child neglect, elder abuse and elder neglect. As a licensed counselor, I am required a mandate to report suspected child abuse and child neglect, elder abuse and elder neglect. I'm also required to report when I deem somebody that is going to harm themselves or harm someone else. There's a third aspect to what happens in our profession is that there's maybe a person that is pushing the sexual boundaries of massage therapists, and that person may be going around to several massage therapists in the community. Questions have come up in these ethics classes. Can other massage practitioners warn other massage practitioners of this person's intent? So because it's not clear, it says required by law, it's not clear specifically of those examples that I gave you. I wrote to our board some years ago, And the answer that I got back was that it was a very difficult answer. The general counsel of our board said, it's not so clear. So one was to think that our confidentiality would be held as stringent as other health practitioners, like psychiatrists, medical doctors, and so forth. I had a little issue with that because I'm not a medical doctor, I'm not a psychiatrist, so that the board needs to be more specific of those requirements. The representative asked me to look up various statutes, and I did, and those really didn't address the reporting. It addressed after the reporting. So I asked for more clarifying information, and basically our board, our state, said that the answer to those three questions is confidentially held if we suspect or experience child abuse or child neglect. And that may be that, let's say we are working on a minor or an elderly person and we see bruises on that person. From a contraindication standpoint, we need to inquire so we know how to treat. And if that person discloses directly that there has been abuse, or the way that they disclose that you suspect it, that's one area that would pertain to us. Of course, the other is if somebody is telling us that they're going to harm themselves, or outright that they're going to harm someone else. So, and the person is pushing those sexual boundaries. Our state has said that we have to keep our clients' confidentiality even in those circumstances. And that raises some eyebrows. This is where maybe your personal and professional ethics may be in conflict. Now, the national certification may be different than the states. There are some ethics books and national board that says protect the public, and underneath protecting that public may be around these issues. And specifically, some of the books talk about exemptions may be for child abuse and child neglect, elder abuse and elder neglect. So even national and states are in conflict. That's why it's so important for wherever you're practicing and you're licensed to see the specific state laws and requirements about those breaches of confidentiality.
Well, do you believe that if enough people inquired about it to the state, that they would then come up with a definition?
I would hope so, and that's why I think that it's up to us to advocate that question of it's our profession. If enough of us either pressure or bring to light to our state's board that we need specific answers around that, or even the aspect of changing some of the rulings. Board members, we elect board members. Those are the ones that make that decision. So we need to get involved in areas of ethics that we don't agree upon, or even areas that maybe the profession is evolving differently than the history and what is stated in past ethical procedures and ethical conduct. So it is beneficial for us to get involved, to ask the board for that specific. I just have an email of our discussions, and so it would be beneficial for us to say to the board, can you be specific about it? So there is one aspect that was specific, that was in a newsletter some years ago, 3 or 4 years ago, after I wrote this to the board, so I'm going to take credit for the reasons why that was in the newsletter. And it was basically about client confidentiality. And it stated that a licensed massage practitioner cannot warn other massage practitioners of a client's intent to push inappropriate sexual boundary, because to do so would breach the confidentiality agreement. However, if a client gave a written consent to the disclosure, then it can happen. And people kind of say, yeah, right. When is the client going to do that? The board stated that a licensed practitioner can have that in their intake form, which is interesting. For instance, to have in your intake form, this is a therapeutic massage. If there is any inappropriate sexual behavior experienced, you waive your right for me to discuss your identity or to discuss that with any other licensed massage practitioners. So it's got to be specific to licensed massage practitioners, not you waive your confidentiality for me to tell anybody. It's specific to license. So you can have that in your intake form. This is a therapeutic massage. If there is any inappropriate sexual behavior, you waive your confidentiality for me to inform other licensed massage practitioners in the community. Then, if it is signed and that does occur in your session, you have that right to discuss. Otherwise, you do not have that right to discuss with other massage practitioners. And again, this is where it may be where your personal ethics may collide with your professional ethics.
So that I'm clear about what we were talking about a few moments ago.
Yeah.
Although I think it would be a rare occurrence for a parent or guardian to bring into a massage a child who is the victim of the parent or guardian's own
Yes.
abuse or neglect. You have to maintain that confidentiality, although you do have the obligation to check the contraindications.
Yes.
What's the source of the bruising or whatever you may see.
Right.
But may you contact the board to say, what more can I do to
Absolutely.
explore this?
Absolutely. Anytime you're in doubt, I think it's beneficial to call the board.
Yeah.
And the board will hopefully give you a direct answer. My recommendation, of course, is whenever you talk to anybody, of course, record the information, who you spoke to and so forth, even if it's another colleague, to get that information. So yes, that would be very beneficial. And if the board adheres that because of confidentiality you can't, it may be that the board will say, as licensed massage practitioners, when it's beyond our scope of practice, we also are required to refer to other health practitioners that's within their scope of practice. So they may say, well, to go ahead and refer that client, the parents, to a psychotherapist, let's say. And again, that may be a little sticky situation if the parent ends up to be the perpetrator of that abuse. But that's why it's very beneficial and required in many sense to have a good referral system, that we refer out when it's beyond our scope of practice. Yeah.
What's the confidentiality like different with minors and parents? How does that differ?
Yeah, usually that when a parent consents, because a parent has to consent for the treatment, then the information also is given to the parents. Very seldom. In psychotherapy, there can be some exceptions with just holding it with the minor, but with us giving consent from the parent or guardian, then that means exchange of information goes to them also. Right. And it's also in some way under our discretion, but I would also say it'd be beneficial to also have that parent and guardian perhaps in the room of the massage session. One, it could create a lot of safety and trust for the minor to have that. And also it could, depends, you might even see that it might make them uncomfortable to have that parent and guardian, but at least discussing it, making the offer to do that. And that way, hopefully, if it is, of course, a healthy situation, then you're bringing in the parent to be part of the treatment plan and to know what's going on, and they feel comfortable of what they experienced that your treatment was. They see the rapport that you have with that minor, and that's just, it's wonderful to have that parent, a healthy relationship that is a good healing treatment group that also includes the parent. Good. Let's see. What else about confidentiality? I think we're covering a lot. Any other questions around confidentiality?
I have a personal question.
Yes.
Well, personal from my experience. So the question involves Facebook. Because a lot of people will be like, I want to see you, blah, blah, and then I will email them or call them. I never respond directly, but it's and I know it's up to them to disclose that they see me, but like everyone and their mother can see that. So am I obligated? Like, should I delete that comment immediately? Is it okay? Like, how does that work?
That's a great question. This is again where the ethics hasn't evolved in new society of social media. It's a real challenge. I do not have a Facebook page just because of that reason. Not the reason of perhaps clients knowing a lot about my personal life, because if I have, many people also have a business Facebook page, and as opposed to a personal Facebook page, because there is an aspect of when the client knows more about your personal life, that information can influence the therapeutic relationship. They may be asking you a lot more personal questions that you may not be comfortable with, because the agreement is for you to be working and focusing on their particular issues. If you don't friend somebody, the feeling of feeling rejected and offensive, it could even be that you haven't checked your Facebook in a week and that person expects to be friended in 5 minutes in our day and society, that can cause a reaction that can taint the therapeutic relationship just in that, the assumptions of being rejected and so forth. And then some inappropriate comments that you feel, whoa, I don't want my clients to really know some of these, or they may misinterpret some of the feedback and the comments that are on my page. So it is a challenge, and I think it's a call that we need to make, knowing that when we do allow our clients to be involved in our personal life, that it is going to open up the door for some more challenging issues. Dual relationships may come in. Having my 50th birthday party, so-and-so is invited, and your client's thinking, well, I'm not invited? I thought we were friends. And that's the difference, the aspect of, in all reality, it's a therapeutic relationship. It's different than a friendship. A friendship is a two-way street. Friendship is, I'm asking my friend how they're doing, and they're going to also ask me how I'm doing. And yes, that happens, of course, in a massage relationship. They ask how we're doing. But we don't take 15 minutes to tell how we're doing. Thank you so much for that check for the session, for me telling you how I'm doing. We don't do that. In friendship, we do that. And that's interesting, too, because Facebook is friend, right? We're friending people. So there is that connotation about that, and that can be misconstrued. So
but in terms of, like, specifically, if someone writes you, like, I can't wait to get a massage from you, like, are we required to delete that type of comment?
If that comes up, because in some way right there, just because you have that page, that client's information is open, that you have a relationship with the client so other people know, I don't think that you may be required, because again, I don't believe that the ethics has caught up to it. It'd probably be beneficial.
Okay.
And it would be beneficial to maybe even talk to your clients if they are on your Facebook friend, that you say, things that are pertain to massage, to respect your confidentiality, I'm not going to have that on my board or wall or whatever it's called.
Well, a lot of them are like the dual relationship situations.
That's right.
That's primarily what my Facebook is, so it's like,
Yeah.
I'm just like, ooh, like, there's certain situations where I'm like, whoa, it's like red flag. It's like, okay, I need to, like, take this conversation off of.
That's right. That's right. And that's what we're going to get into after we take a little break. We're going to get into dual relationships, where the dual relationship, the ethics around dual relationship is avoid relationships. I'm looking in the camera. Avoid relationships with the client that could impair professional judgment or result in exploitation of the client. So it doesn't say do not do dual relationship. It says avoid relationships that can impair professional judgment. And we need to discuss what things can impair professional judgment. So we'll do that after we take a break. Thanks.